Good afternoon, ladies and gentlemen, and welcome to our panel today, this afternoon, where we are going to discuss the misuse of data in the context of modern conflict. I'm honored to moderate this panel, and after a short introduction, I will introduce my speakers, and then I will give them a word. Most notably, with the invasion of Russia into Ukraine, the last years have seen a resurgence of the discussion of legal questions related to international armed conflicts. At the same time, modern conflicts from Ukraine to Israel showcased that data and information are a decisive commodity in the 21st century, on and off the battlefield. Using data allows for more precise targeting operations, enables military operations to be more efficient, and can help with the distribution of aid in cases of humanitarian need. The flip side of the unprecedented amount of data and increased usage of data is the potential to use data in an adversarial way. When knowledge is power, information and data in the wrong hands can very much be a dangerous weapon. Personal data, for example, can be used to exploit and coerce not only members of the armed forces, but also civilians. While false information has the potential to influence and confuse entire populations in peacetime as well as in conflict. This array of possible use cases challenges not only established IHL concepts, like combatants and civilians, but it also poses serious questions to the intersection of different legal regimes. Therefore, it is my pleasure to introduce you to a panel that not only tackles some of the most pressing legal issues in this context, but also presents a wide variety of topical problems, all held together by the predicament described. The first presentation addresses the post-occupation retention and use of data collected by the military, which has received little attention so far. The speaker will present a preliminary analysis of the international legal framework regulating the situation, addressing both international human rights law and international humanitarian law. This is followed by a discussion of the legal framework for military psychological operations, a special type of military operations which can be enabled by data and information. This presentation continues the discussion about the interrelationship of international humanitarian law and international human rights law, while offering practical solutions to reconcile both regimes with each other. Both papers you can also find in CyCon's book from this year, and I strongly advise you to read it. Finally, we are going to go deep dive into the famous case of RT France versus the Council of the European Union, highlighting yet another legal predicament. When disinformation becomes a danger to society, the restriction of broadcasting rights can be justified. This case study highlights legal responses to address the adversarial use of information for influencing civilian audiences. By doing so, this discussion sets a counter perspective to the IHL-centric discussion of the first two presentations and should incite a lively discussion at the end of this panel. So without further ado, it is my pleasure to introduce the first speaker. The first speaker is Tatjana Grote, who is a PhD candidate at the University of Essex School of Law. Her research focuses on the international regulation of the military collection, retention, and use of civilian personal data during armed conflict. She holds a Master of Laws with a specialization in public international law from London School of Economics and Political Science. Her presentation will be about reflections on the afterlife, which rules govern the post-occupation retention and use of personal data collected by the military. She is doing her PhD exactly in this area. Thereafter, we will listen to Anastasia Roberts, who is a lawyer with 26 years of legal practice. Following 20 years of service with the British Army in the UK, Iraq, Afghanistan, Sierra Leone, Australia, Germany, and most recently in Belgium with NATO, she is now an independent legal consultant. She is a specialist in operational law with significant experience in intelligence, cyber, and strategic communications. She is now focusing on legal training and exercise scripting and execution for military and civilian clients. Anastasia has a master's in technology, media, and communication law from Queen Mary University, London. Today, Anastasia will talk about military psychological operations in digital battle space, a practical application of the legal framework. This was one of her focus areas at her last posting to NATO SHAPE. Last but not least, we will listen to Petra, Mahnič, who is legal advisor at the Council of European Union. Petra has been a member of the EU Council Legal Services since 2004 and a tenure as a legal advisor in the Constitutional Court of Slovenia. Her areas of specialization include EU common foreign and security policy, common security and defense policy, EU restrictive measures, and public international law. She provides legal advice to various council preparatory bodies and acts as a council agent before the European Union courts. She is a co-organizer of executive training seminars on EU restrictive measures at the European University Institute of Florence School of Transnational Governance in Italy, and a visiting professor at the College of Europe Legal Department in Belgium. Petra will walk us through the case Artifrance versus the Council of the European Union. And now we will start our presentations, and we will be happy to take your questions at the end. Please, Tatjana, the floor is yours.
Well, thank you very much, Hele. I'm extremely excited to be here, and I'm very excited to talk about a topic that is probably as specific as it can be significant for those affected. As Hele already mentioned, I'm going to talk about the international legal framework governing the post-occupation retention and use of data collected by the military. Now, one preliminary remark. This presentation, if after you have more questions than answers, good. That's kind of what it's supposed to do, because it is really meant as a discussion starter. So really, I think, since there's not much out there on that topic, it's a very preliminary analysis that hopefully will get us all thinking a bit more about this. Now, the first question you might have is, why should we even think about it? It seems oddly specific, post-occupation data. Now I'm going to illustrate why we should be thinking about this with reference to Afghanistan. Next short disclaimer, this is not a legal classification of what happened in Afghanistan or what is potentially currently happening with data collected there. It is really just to illustrate why this topic matters. Now, what happened in Afghanistan? In Afghanistan, we saw the large-scale and systematic collection of biometric data by the US Armed Forces mostly. Now, reportedly, the goal was actually to register up to 80% of the Afghan population in a database that hosted mostly biometric data, but also biographic information on, for instance, the occupation of data subjects, their family, and most importantly, their engagement with US Armed Forces. You might wonder, again, why all this effort? And some of you in the room will understand this much better than I do, but to break it down, especially in situations where the military exercises control over a foreign territory or a foreign population, personal data can be uniquely valuable. It allows to quite effectively actually answer this perennial question of friend or foe. It allows to enhance situational awareness significantly. And perhaps it might even serve to deter insurgent activity by really demonstrating we know who you are and we know what you're doing. So I think it's not too surprising that we're seeing this trend, not just in Afghanistan, but also in situations of military occupation, like Israel-Palestine. It also happened in Iraq, and I would be surprised, well, we will see probably in a couple of years, but there are good reasons to believe that it is also happening in the Ukrainian occupied territories. Now, why are we having a legal panel on this, though? I think the presentation is basically the answer to that question, but I'm going to say already that personal data is not just data, and if you're sitting in this room, I think you'll probably know this. Personal data, especially in armed conflict, can enable significant economic, physical, and emotional harm. And I think the reason why I got interested in this topic is this doesn't change once armed conflict is over or once an occupation is over. The data kind of stays the same, and very often the potential to harm also kind of stays the same. Take the example of Afghanistan again. When the US armed forces left, they left behind certain biometric data sets that were then picked up by the Taliban and reportedly used to retaliate against individuals who have cooperated with the US armed forces. So here we really see that it matters what happens to this data even after a situation of military control or occupation ends. And I think this crucial role of data is actually well appreciated in the literature, at least when it comes to peacetime and the conduct of hostilities. There is significantly less engagement with this question when it comes to situations of military control and occupation, and to the best of my knowledge, no engagement with the question of what happens after such a situation. And this means we need to kind of engage with the mother of all legal questions, which is what rules apply in this situation. Now, maybe a short explanation. Obviously, there are different situations of military control. I'm going to talk about occupation specifically because I think this is still probably the most common one, setting aside the legally more complicated ones, let's say. Now, to be clear, what is the scenario we're talking about? We're talking about State A occupying State B, collecting civilian data from the population, or personal data from the population in State B. Then then State A brings its troops back home to its territory, but retains the data it collected from State B. So this is the situation we're talking about, and the question is which rules apply to this data and whatever State A decides to do with it. And I think one obvious candidate here would be international human rights law. But we will see in a second that it's actually not as straightforward as one might think. A short note on data protection law here. Data protection law can definitely be relevant and applicable as well. But this is a case-by-case assessment, so I'm really going to focus on the international regulation of this. And also maybe two notes on this. So for instance, Afghanistan didn't have a data protection law at the time. And for instance, if you look at Israel, there's a very broad exemption for the police, the general secret services, and the Israeli defense forces. So I think, although it is a case-by-case assessment, there will probably be situations where domestic data protection law will not be applicable, which means we look at the international level. And when it comes to human rights law, I really have to say this could be a panel on its own. So forgive me if I'm using relatively broad strokes here. But the basic problem that we have is that basically, and most of you or many of you in the room will know this, many human rights treaties are limited in their scope to individuals who are located within the jurisdiction of the contracting state or the state in question. Now, jurisdiction traditionally has been interpreted as the territory of that state, which in our case is not the case because the data subjects are in State B, not State A. There are two exceptions here that are relatively well accepted and established. One is effective control of a territory. That would precisely be occupation, but we said the occupation is over, so that's not pertinent. The other one is state agent control and authority over an individual. So when a state agent exercises control over an individual abroad. Now, this is a bit more complicated, but if you look at the case law, especially of the European Court of Human Rights, they really emphasize that there must be an element of proximity, of physical proximity, which in our case is, again, not really pertinent. So I would argue that under those traditional approaches, our situation would not be governed by international human rights law. Now, there are some more flexible approaches, one called the functional approach, most notably. This has been picked up by, for instance, the Human Rights Committee and the Inter-American Court of Human Rights with respect to climate change and the right to life. And the basic idea here is whenever a state is in a position to directly, significantly, and foreseeably impact the enjoyment of human rights of a person really anywhere, its human rights obligations will be applicable. However, this has never really been used in the context of the right to privacy, and the European Court of Human Rights has repeatedly and very explicitly rejected this. Speaking of the European Court of Human Rights, that court has gone down a different route, and a very interesting one, because it basically said, well, when data is processed or collected in the territory of a contracting state, then the violation, the interference and the violation happens within the jurisdiction of that state, and hence its human rights obligations are actually applicable. What would that mean for us? That would mean if State A decides to take that data back to its territory, store or process it there, its obligations under the European Convention would be applicable if that case stands. But, big caveat, you see it already, State A would have to be a European or contracting state to the European Convention. Second, I should say this is a lower instance, so it's not a Grand Chamber judgment. It is also a peacetime judgment, and I have my doubts if the court will use the same reasoning or apply the same approach in cases related to armed conflict. And then lastly, I mean, State A could also simply decide to store the data in some third state and to also process it there, and hence kind of circumvent its human rights obligations even under this approach. So we're not going to solve all these questions today, and I'm going to stop bothering you with these complicated questions of extraterritorial applicability now, and just say what this, I think, really demonstrates is that it is simply very unclear if, under what circumstances, and to what extent international human rights law would apply to the situation that we're looking at. Which means we need to look at international humanitarian law. Unfortunately, the questions of applicability are not any less thorny here. And I'm going to start with actually taking a step back, because if you think about it, maybe one could actually say, well, okay, the troops maybe went home, but what if simply retaining that data from the population in State B actually constitutes a new form of occupation? Now, how do we answer this question? We look at the treaties. Occupation is defined in Article 42 of the Hague Regulations, and the crucial term here is actual authority. This has been interpreted by most as effective control, and effective control, again, is a very disputed notion, but I think two debates are of specific relevance here. The first one is, do you need boots on the ground? If you answer that question with yes, then clearly simply holding data would not qualify as occupation. But even if you don't, the thing is, I think many would agree that the control kind of needs to be exclusive. There cannot be another authority exercising significant influence at the same time. And personally, I just don't see a situation where simply holding personal data would give you that level of control. So I don't see how State A, simply because of that data it has, could completely incapacitate the sovereign in State B, which still has, for instance, territorial control. And in conclusion, I think it's difficult to come to a different, or not to come to the same conclusion as the Talon manual experts, actually, who said that there is no such thing as cyber occupation, and I think in analogy, under the law as it stands, there's also no such thing as data occupation, which means law of occupation, by virtue of there being an ongoing occupation, would not be applicable. There is, however, another applicability threshold that is of relevance, and I think we're going to maybe also hear a little bit more about that in the next presentation, potentially, because there is Article 4.1 of the Fourth Geneva Convention, which defines protected persons. And there is some debate on this, but I would argue that all protected persons enjoy also the protection that is provided in Part 3, Section 1 of the Fourth Geneva Convention. And I'll come back to that later, but basically those are very general protections of the person against humiliation, against moral coercion, and I think those are very interesting and very relevant, actually, in the context of personal data. So if State A controls personal data from individuals in State B, are those individuals in the hands of State A and hence protected persons? I believe the answer under the current law is no. Because although the in-the-hand standard is a bit more flexible than the effective control standard, it still has mostly been applied in situations where there is still physical control. Maybe less permanent, less stable, but still it's that kind of situation. So for instance, if you look at the ICOC commentary, there it defines in the hands with reference to territory still, so it's still a kind of a territorial concept. And also if you look at how the International Criminal Tribunal for Yugoslavia has interpreted it, it mostly looked at it in the context of what we call the invasion phase. So armed forces establishing control over territory, but not being quite there yet. So I think it might be a different level of control, but not necessarily a different type. Now, I'm going to flag something here, and let me be very clear, this is not at all the law as it stands, but since we have many smart people in the room who might have very interesting thoughts on this, I'm going to simply mention it here quickly. If you think about what data means to us in our modern lives, I think there could be an interesting new interpretation, maybe, where we could wonder whether when a belligerent party holds a certain type of data, a certain quantity maybe of data, this could also be considered as control over that person. And that would mean that this data kind of becomes the virtual extension of a person. Because if you think about it, the picture that you can get from a person through data nowadays, I think, is very complete. You can almost see their entire lives in data. And given that this data is so intimately connected with who we are as people, I believe that this could be something to be explored further, with obviously the big caveat, let's say, that first, this is not the law as it stands, and second, it would need significant further conceptualization, as in how would that work precisely. But I think it's interesting to think about this, because I think this situation that I'm talking about kind of shows how, there might be more ways in reflecting what data means in the modern world in general than to, for instance, just look at it as an object. But, let me be clear again, as of now, the in the hand standard does not refer to a situation like that, and so simply holding data over an individual or of an individual would not bring that individual in the hands of the belligerent party. Now, just to recap, this is actually a bit problematic, no? Because if we think about it, we said data protection law, case-by-case assessment, but might not apply. International human rights law, very unclear if it applies. The law of occupation, based on an ongoing occupation, also doesn't apply. The general protections from the Fourth Geneva Convention, also not applicable. So really, what is applicable? Now, I would argue that there can be at least a convincing argument that certain obligations from the law of occupation can actually outlast the exercise of effective control over territory. I'm not saying this is definitely the law as it stands, but I would say that it has been gaining significant traction in the literature, and it has also been endorsed by the ICRC, so the International Committee by the Red Cross, although not in the context of data. Now, this endorsement is not universal. There are some voices who say this will fragment the law of occupation, and there's a need to justify that asymmetry, because basically what you'd be saying is, we determine whether the law of occupation begins to apply with respect to the effective control standard, which is a very strict standard, but when it comes to determining the end of the applicability of these rules, we apply a different test. Now, why would we do that? The idea behind it is that, this binary on-off approach of effective control, law of occupation, no effective control, no law of occupation, it simply very often doesn't reflect the reality of occupation, because frequently an occupying or former occupying power will retain what the ICRC has called key elements of authority, so some sort of influence. And if the law of occupation does not apply, there is a great risk for a significant gap in protection. And I think this is precisely the case for data, because, again, think about it. State A still holds that data and can still use it to harm the data subjects. So there is a need for protection here. And I think that data might even be a good example to also justify that asymmetry. Because if you think about it, so how I see the law of occupation is basically, it's based on the idea that these obligations are the flip side of the control that an occupying power is exercising. You have a situation where a foreign state suddenly exercises effective control over foreign territory and the population, and so there's a need to regulate that control, and more importantly, the dependence of that population on the occupying power that is created through that territorial control. In a normal peacetime situation, there would be domestic law to do that, but because it's a foreign power, we don't have that. And so that is why we need the law of occupation, to regulate these dependencies created through territorial control. And if you think about data, that's precisely what's happening, in my eyes at least, because of that territorial control, the occupying power, former occupying power, will collect data, will create these links of dependence between itself and the data subjects, or the occupied civilian or occupied population. And I think if the occupying power decides to maintain that relationship of dependence, even after the end of kind of effective control over territory, then it would only be fair that it also kind of needs to oblige with certain or comply with certain obligations that comes with. So again, I think if you see these obligations as the flip side of this dependence that is maintained, and also really emphasize that decision, because state A could also simply delete that data. It is kind of only fair that certain certain pertinent provisions will remain applicable. Again, this is just my view. I'm not saying that this is the law as it stands, but I think it's something to think about and maybe also elaborate on further. Now, I keep talking about pertinent provisions and relevant obligations. What are these? I'm going to be very quick on this because it's really a case-by-case assessment, because it depends on the data that the occupying power would retain and what that means kind of to the data subject. But in short, I think it would mostly be these actually negative obligations, simply to borrow from human rights here a little bit, to not humiliate, to make sure that data is not used to physically harm someone or to allow for physical harm, not to punish. And so it's really, there are still many open questions regarding the precise contents of these obligations. But I think in general you can see that it's very limited protection. It's really just protecting kind of the basic honor and dignity of a person. And so in that sense, human rights law would probably be a lot more suitable to provide effective protection if you come from that perspective. But again, as long as we're not entirely sure if or when it's applicable, these might be very, very important minimum safeguards. And being mindful of the time, I will conclude with 3 main takeaways. The first one is data and data protection matters during armed conflict, during military occupation, and also after it. International human rights law might be of help, but it's very uncertain to what extent it's applicable. So I think for the time being, really do also need to engage and look at international humanitarian law. And on that end, again, I would think that there's a convincing argument to say that there are certain obligations which can continue to be applicable even when there's no longer effective control of a territory. Now, I will come back to the first thing I said, which is this is very preliminary. There's so much more to be explored here and to be clarified here. But I think, if anything, this presentation should really be seen as a reminder that as we start talking more and more about data protection during armed conflict, it is really important to cover all bases, kind of. So to not forget about any situation that is related to armed conflict or regulated by IHL, and also in a temporal sense, to think about the before and to think about the after. Because, I mean, you all know probably conflict kind of comes and goes, but data can stay, and I think so should our attention. Well, and with that, I will thank you for your attention and give it back to Hele. Thank you very much.
Thank you so much, Tatjana. Now we are going to Anastasia. Yes, please.
Good afternoon, everyone. So thank you very much, Hele, and thank you very much, ladies, for allowing me to join this all-female panel, which I think is something to be proud of in itself. And obviously, thank you, CCDCOE, for facilitating this, and also thank you to my co-author, Dr. Adrian Venables from Caltech, who isn't here because he's battling through thesis defences for his students, but I suspect he will make it for gin and tonic this evening. So, moving on. Just before we dive into the detail of what we're going to talk about, I just wanted to give you the definition that I used in writing this paper, the definition of PSYOPs. This is NATO's definition, and the reason I used it is because it indicates a degree of consensus between a relatively large body of states, which can be difficult to get in this field. But that's just to set the scene. So this slide sets out the purpose and scope of my presentation, and I'm just going to draw out some points from this. The first is about clarifying the legal framework. So my paper received some criticism for not breaking fresh academic ground, or not adding anything new to this discussion. But quite frankly, that wasn't my intention. My intention was simply to try and restore some order to what has become a confused space in my experience. So why has military psyops become a confused space? Well, first of all, as it says on the slide, it's the increasing complexity and scope of psyops, given the advances we have had in ICT. Now, when I was a LEGAD in Afghanistan, it was quite easy. I sat in my legal office in the headquarters. The psyops team would bring me their draft products. So in those days, it would be draft leaflets for distribution or draft scripts for radio in a box. And that really wasn't too challenging because, of course, at that time, it was quite controlled. It was limited to the area that the leaflets were going to be distributed on or the reach of the radio broadcast, radio in a box. But if we think about today and we think about the internet, we have an almost unlimited target audience and available 24/7, given the increase of smart devices. So the reach of psyops has significantly extended. Also, in terms of the depth of psyops, we know that military personnel in Ukraine have received personalized messages directly to their own smartphones, messages that not only refer to them by their name, but refer to the names of their family members, where their family members are. And all this, of course, being in an effort to coerce people to surrender, to lay down arms. Now, I don't know about you, but for me, there is something incredibly sinister about receiving such a targeted message on my own smart device, as opposed to picking up a leaflet off the ground. And then finally, we have to recognize the fact that psyops can now be affected in very, very covert manner, in manner that people may not even consider that they are being influenced. They may be completely unaware of it. And this is with the use of false personas on social media, the planting of false news, fake websites. So I wholeheartedly agree with those who criticize my paper in the sense that the law perhaps has not changed, but certainly the practical application of the law, the context we are looking at, has changed. And the second point, the second thing that makes this area so much more complex now is the resurgence of international armed conflict. In my 20 years in the military, and I only left in February, there was almost constant focus on non-international armed conflict and situations below the threshold of conflict. And that was military level, state level, even academia. But let's look at the geopolitical context now. Let's look at Russia, Ukraine. Let's look at what's happening in Israel and Palestine. Let's look at the increasing tensions between China and Taiwan. So although it was once thought that IAC was probably never going to threaten us again, particularly in the European continent, I just don't think we can say that anymore. And so militaries, states, have to now start to refocus on international armed conflict and how we fight, how we conduct ourselves in full warfighting. The other issue in relation to international armed conflict is because we're not used to applying it anymore, we have lost our familiarity with LOAC, with international humanitarian law. It is very complicated for military personnel because we've been so focused on NIAC and situations below the threshold of armed conflict. And we know that different legal regimes apply. We have one legal regime in IAC, a different legal regime in peacetime. Even NIAC is subtly different from the legal regime in international armed conflict. And yet we're expecting military personnel to chop between those different layers. And then add to this the fact that, at least for the last 10 years, we have heard consistently about the blurring between armed conflict and peacetime, this elusive grey zone of activity that has been the focus of much academic debate. And then add on top of that the fact that we have, and have had for some time, this ongoing conflict between international human rights law and IHL and LOAC. We know IHL is the governing body of law in armed conflict, but we also know that as a matter of legal principles, international human rights law applies as well. And this can be very confusing for military personnel to understand, including myself. So really, all of that to say that the purpose of this paper was to provide some sort of practical help to militaries, a paper they can just pick up and read and hopefully understand and then build their knowledge upon. The final point I haven't drawn out is that of civilian protection. So because the tension between IHL and international human rights law is at its highest when it comes to civilian protection, that is what we decided to focus this paper on. Which takes us on very nicely to the tension between IHL and human rights law. And thank you, Tatjana, for covering off quite a bit for me already. When I was preparing this paper, I read a lot of academic papers, a lot of books, and I was quite shocked in a way by the criticism of international humanitarian law and the assertion that it is incapable of fully protecting the civilian population from the effects of PSYOPs. And I read even in one paper asserted that the only protection IHL offers is the prohibition on perfidy, which I just don't think is correct, and we'll move on to look at this. But it is nevertheless fair to say that IHL itself, the Geneva Conventions, the additional protocols, do not make any direct reference to PSYOPs. PSYOPs are generally considered as ruses of war, which are lawful as long as they don't contravene any other aspect of LOAC. And ruses of war are measures designed to deceive the enemy. It's military deception, make the enemy act recklessly. All the things that we could conceive would happen in armed conflict. Okay, so there's no direct reference to PSYOPs in IHL, but we have to think about the context in which the Geneva Conventions were written. And at that time, the primary concern was to safeguard civilians from the effects of kinetic force, from the effects of attack. That was the principal concern. And I have to be honest, when we look at Russia and Ukraine, I think that still remains the principal concern of IHL. So, extensive provisions in IHL that protect in terms of attack, use of force. But we know, I believe we would accept that an attack is not just about the means we use, it is also about the violent consequences. So it is clear that PSYOPs that are expected to produce violent effects are attacks and should be regulated as such. And so trying to come up with some examples, perhaps PSYOPs that encourage violent disorder, civil disorder in a civilian population to destabilize the enemy state, or PSYOPs that persuade civilians that they should be drinking harmful products. And by that, I clearly am referring to, or drawing on what happened in COVID, where we had such a huge amount of disinformation that people were drinking bleach, huge amounts of alcohol, and even eating manure. So you think sometimes, well, nobody would ever believe these things, but I think we'd be naive to think not. But the reality is, and this is my view, and I don't know if anybody shares that view, but it's my view, the reality is, I doubt that very few PSYOPs will reach the level of producing violent consequences. So then we have to ask ourselves, what about PSYOPs that aren't expected to cause any violent consequences, any violent effects? And here is directly where we hit international human rights law, and specifically the human rights of privacy and freedom of opinion and expression, because there are no IHL provisions that directly tackle these subjects. So let's just break that down a little bit and see how this might be of concern. So, Everyone has the right of freedom of opinion and expression, and we know that this includes the freedom to hold opinions without interference. But the problem is, if you look back at the definition of PSYOPs I just showed you, PSYOPs is entirely about trying to influence people, trying to change their attitudes, their perceptions, their beliefs. So we have a direct clash. But also, very importantly, the right also includes the right to seek and receive information, trustworthy information, true information. And we can see how awfully important this is in the context of armed conflict, where we have civilians who need information to protect themselves. They need to know where safe zones are, where evacuation routes are, where they can find medical support, even where the fighting is taking place, so they can avoid it. So a really important right that does not sit easily with the idea of PSYOPs in terms of the manipulation of information online or the planting of false information. And then we move to the right of privacy. And in this respect, we can see how privacy, this right, may be engaged if, for example, we wish to publish private, personal, sensitive information about somebody to discredit them. So this is the concern. We can't just say, human rights, forget it, we've just got IHL. We still need to think about these concerns because they're very real. But of course, the problem we have with human rights law is what Tatjana has already very kindly covered for me. We have the issue of extraterritorial application. A state will only be bound to uphold its human rights obligations where there is extraterritorial application. And as we know, that is complicated. It is definitely not settled law. But even when there is jurisdiction, which rights apply? Jurisdiction does not equal the whole range of human rights. In fact, when we're talking about effective control, it is understood that effective control how effective that control is what will determine which rights apply. So in a situation such as occupation, where a state may have control akin to it in its own territory, we may expect the full range to apply. In relation to the jurisdiction clause of state agent, physical power and control, case law is clear that this will depend on the personal circumstances of the individual concerned, the rights that are relevant to that individual. So not only is it unclear when jurisdiction will arise, it's also unclear which rights will arise. And then we also have the interaction between IHL and human rights law. And people will glibly say, well, the two will mutually complement each other in their interpretation in a situation where human rights and IHL apply concurrently. But just look at what we've talked about for PSYOPs. There is a direct conflict between them. And when there is a direct conflict between the two bodies of law, this will require a policy decision. And so that the scope for confusion, misunderstanding, and incorrect application of the law is really quite extensive in my view. And also derogation. Of course, these are rights that can be derogated from should a state choose. We've seen very little state practice, but things may change. And so, as I've said, I'm not trying to dismiss human rights law. It is incredibly important. But I was, until very recently, a military legad. And in that context, it is really important in military training and planning that you give very clear parameters for proposed activity, that you try to avoid context-based solutions. Nobody hates the lawyer more than when they say, oh, well, that depends. You can see an entire audience just die in front of you. So we have to try and be quite clear about the advice we give, the guidance we give, so that our operators know what they can and what they cannot do. So contrary to human rights law, IHL has no context-specific degree of application. And so I personally would favour an approach where we concentrate on military planning and training on IHL. But even then, as I've said, we can't just forget what we know about human rights. They're genuine concerns. So can IHL be addressed, can the human rights concerns be addressed and encompassed by IHL? And I personally think they can if we adopt a purposive and most of all a common sense approach to this. Because remember, the focus of IHL is to protect civilians. That's all we really need to think about. And so, as I've said, IHL actually has a number of specific provisions that are applied when considering PSYOPs. I have applied these myself on operations. So the first is the prohibition on terrorising the civilian population. Attack or threats of attack that have the primary purpose of instilling fear in the civilian population, so making them feel terrorised, scared, that is prohibited by IHL. An example that is given actually in the French operational law manual is one of telling the civilian population that they will be attacked if they do not leave an area. So this is a key provision. And just going off slightly, it's very important that you also consider where you are disseminating your PSYOPs products in this respect, because PSYOPs products that may be okay to disseminate to the enemy may not necessarily be the same for civilians, your civilian audience. So that's a very realistic consideration. And then we have the obligation to respect and protect medical personnel and facilities. Now, we know this is more than just protecting, it's respecting, which means not interfering with their humanitarian function. So in this context, I would think about PSYOPs that maybe seek to undermine and discredit medical facilities and personnel so that people won't use them. And again, I'm drawing on COVID because look what happened with the COVID vaccine, the injections. Because of disinformation online, people were not going to be vaccinated. And then we also have the obligation to respect and protect the dead. And again, this is of direct application because we know that you cannot use the bodies of identifiable deceased on PSYOPs products. That would be contrary to the obligation to respect and protect the dead. So that's just a taste of the specific provisions. But then we have two more general provisions that I think get largely overlooked, or perhaps we've forgotten about in all this time we've been focusing on situations below the threshold. And the first is the obligation to treat civilians humanely. This is obviously comes from Common Article 3, which sets the benchmark for the humane treatment of those who are hors de combat, who are not taking any part in hostilities. And it's set out there because you have CA3, and then that is built upon by specific provisions in IHL. And for civilians, we will be looking at Article 27 of GC4, as Tatjana mentioned. And so you will see that these provisions are very, very similar, in fact, almost word for word, I think, to the provisions that we probably know better in relation to prisoners of war, other categories of captured persons. And in that respect, the ICRC commentary on GC3, the equivalent provisions, is really helpful. Because it says this is more than just making sure that we do not physically mistreat someone. It's also about their intellectual rights, their intellectual self. And so publishing people's names and photographs or aspects of their personal lives should not be done. Individuals must not be slandered or insulted. But I think what's important here is to remember it's not just about reputation and private life. You also have to think about the potential physical effects of publishing information about people. So, for example, if our enemy was a state that is very hostile to LBGT populations, you'd think I'd know that coming from Brighton, and we publish information that is suggesting that somebody belongs to that community, then that could have real physical repercussions for that person and for their family and for their friends. So it's really just about taking a common sense approach to these things. And then another provision that I don't think gets enough attention, but which I have applied, is the obligation of constant care in AP1. Now, the key point about this is the use of the word operations. In this context, is operations synonymous with attack, or is it broader? And of course, if it's broader, then this would bring in PSYOPs operations that do not entail violent consequences, which would fall under attack. It would give us more of a hook to look more broadly at some of the other consequences. In my view, I think it is broader. I think operations is a broader term than attack. Attack for me is use of force. Operations is more than that. And I say that because the article that follows refers to attack as opposed to operations. I also looked at the ICRC commentary, which gives a broader interpretation, but also the UK LOAC manual, which is online, it's open source, and you can see that in that it is said that military operations has a wider connotation than attacks and would include the movement or deployment of armed forces. So from that, I take a broader interpretation. And in terms of the scope of the obligation in the UK LOAC manual, this is in practical terms what it says the commander will have to do. And so it is quite simply bearing in mind the effect of your proposed activity on the civilian operation, on the civilian population, and taking steps to reduce that effect as far as possible. So that to me is not really rocket science. That is something we can very easily consider during military planning and considering training. And so, hence, we move to my recommendation. And again, I was told that my recommendation was unambitious, but I don't really care. My recommendation is that when we are training military PSYOPs for international armed conflict, when we are planning, IHL should be the overarching framework. All proposed PSYOPs, whether they are attacks or not, should all be subject to a comprehensive assessment and authorization process that is akin to the time and care we take when we are talking about kinetic targeting. And also, as with kinetic targeting, it must be legally supported and also POLAD supported, I would add. So, that is my rant about military PSYOPs, and I'll now pass over.
Thank you so much, Anastasia. We give it to Petra now. Thank you.
Thank you very much. Thank you to the organizers for this brilliantly organized conference and invitation. So my task today is to walk you through, as already announced, a judgment, a very important judgment issued in 2022 in relation to restrictive measures that the Union, together with some other partners, adopted after the invasion of Ukraine. So just to give you the idea of how I'm going to approach this, I'll first give you a little bit of context, explain how this broadcasting ban came about and what it consists of, and then I'll walk you through the main arguments of this judgment delivered by the General Court, First Instance Court, which was not appealed against, so it remains the established law. And then I'll briefly just mention a few other EU responses to disinformation and propaganda campaigns. So let me recall first that the European Union has restrictive measures in place already since 2014. So after the annexation of Crimea, a comprehensive package of measures were adopted, but of course these measures were obtained and also built upon. But after the spring 2021 militarization at the border, of course, the European Council and its other institutions, High Representative and so on, called Russia to de-escalate. And this, of course, didn't happen, as we know. And then in 21st February 2022, the president signed a decree recognizes the independence of the two self-proclaimed republics of Donetsk and Luhansk. And that and the EU responded with the first package of, as we call it, sanctions, restrictive measures immediately after. Now then, on the 24th of February, the war of aggression started, and immediately EU, as announced, also adopted its second, and very quickly after that, at the end of February, a third package, which included different types of measures, of individual application, of general applications, of sectoral measures. For example, in the third package, we had the closure of the airspace for Russian aircraft, de-swifting, immobilization of the sovereign assets of the Central Bank of Russia. Now, then, on the 1st of March, actually, another amendment was brought about. The Council adopted the so-called broadcasting ban. So the provision in question is here on the screens, that is basically a provision that you find in the Council decision and that prohibits all EU operators to broadcast the content, any content of these of the legal persons and entities listed in the annex. That annex at the time consisted of 6 entities, so the group of Russia Today and Sputnik, and it was adopted with time limitations, so until 31st of July 2022. That 31st of July was actually the regular renewal period for the whole package of sanctions. And it was also stated, as it is the case for any restrictive measures that the EU adopts, that they would be under constant review. Now, really, very quickly after, a week after, Russia Today France brought a case challenging against the Council before the European Court, General Court in Luxembourg, basically challenging those measures. They also applied for interim measures, and the court then, of its own motion, so very quickly afterwards, it's quite unprecedented the speed at which the court was reacting, decided to hear this case through a so-called expedited procedure, so very quickly, and it also referred the case to the Grand Chamber, which is 15 judges instead of a panel of 3 to 5, which is normally the case for this, for the review of measures adopted by EU institutions. Then in March, so a week after the application for interim measure was dismissed, basically the court says that there was no urgency and that the balance of interests was more in favor of the Council. And on the 10th of June, we had the oral hearing and the judgment delivered just before the renewal, the due renewal of the measures, so end of July 2027, so just in time for the Council to see what kind of decision, whether it could maintain the measures or not. Now, first, the court first addressed a very important question. It was not expressly raised by Russia Today, but somehow the court felt obliged to look at this question also because there were some references to the decisions taken by national authorities, or rather the lack of that, and so the question of the competencies of the Union to adopt such type of measures was raised. And the court addressed that. I here list a few articles from the Treaty on European Union that the court is citing from, and basically agreeing with the position of the Council that there was no doubt that the Council had a power to adopt such a decision in the framework of its common foreign and security policy, which is defined in those articles and which provides for a clear legal basis to adopt measures, general approaches of a geographical, of thematic nature that are set out in Article 29. So this was the legal basis for the common foreign and security policy decision, which was then accompanied by another regulation on the basis of another treaty that basically produces direct legal effects on the EU operators in the EU. So you need 2 acts to basically enact the measures that are adopted on the basis of foreign policy in the EU. Now, what is important, and what I also put here on the slide, is how the court defined the objectives of those measures. Of course, the court looked at the justification provided for in the act itself, in the recitals, as we call them, that are set out and that explain the measures. And there the court, for example, referred to the need to protect European society against disinformation and destabilization campaigns conducted by the media outlets that are under the control of the Russian Federation leadership. And basically uphold and recognize that the threat to the Union public order and security was there, and this is the kind of objective that can be linked to the objective set out in the treaty itself, which basically allows the Union to uphold and basically pursue the objective of upholding its own interest, security, integrity, and so on. So it said this was the right objective, the objective you can pursue through the measures within this policy framework. Then there was also quite interestingly the reference to the fact that this measure was part of a broader strategy that the EU basically adopted in reaction to Russia behavior, and so that its objective was basically to put an end, to exert pressure on the aggressor state to change its behavior and to put an end to the aggression against Ukraine. So this is clearly linked to the objectives of preserving peace and preventing conflicts and ensuring international security, something that the EU recognizes in Article 21(2)(c). And then finally, which is quite interesting, because until this judgment, all the measures that were challenged before the court were normally the first 2 objectives just mentioned would have been recognized, but for the first time here the court also looks at the very phenomenon of disinformation and recognizes, it states that this is now an integral part of the arsenal of modern warfare, and therefore, because it's capable of undermining the foundation of democratic societies, it also refers to the values on which the Union is based, and which the Union is actually obliged to promote and uphold in the wider world. So these are the values of democracy, rule of law, human rights protection, and so on. So it was clear, so from this, that the competence was there for the Council to adopt such measures. Now, then the applicant brought 4 pleas. They were, of course, all these were related to the violation of fundamental rights, human rights. They were referring to the alleged breach of rights of the defense, freedom of expression and information, freedom to conduct business, and a violation of the principle of non-discrimination on the grounds of nationality, claiming basically that just because their shareholders were Russians and not, for example, French, they were treated illegally in a different manner. And so, as you probably know, the court dismissed all these arguments, and I would try now to address just the 2 pleas, which I believe are the most important for the development of the case law. This is the rights of the defense and the plea related to the violation of freedom of expression and information. Now, first, as regards the rights of the defense. Now, as I didn't mention, but basically there is a rule, of course, that before you adopt measures that affect the legal position of an individual, of a legal entity also, you need to basically notify a person. This is the so-called right to be heard before a measure affecting your position is adopted. In the context of the restrictive measures, EU restrictive measures law, the court has recognized that there can be a derogation to this right to be heard, and that's in particular as regards so-called asset freeze measures, so measures freezing the financial means of people put on the list. Now, so that was the only derogation there was, and all other measures that affect individuals should in principle be notified. This was not done in this case. I showed you the time frame of these actions. Everything happened very quickly. And so there was, of course, a big question as to whether the fact that the Council did not notify the listed persons on the list could interfere or violate their defense rights, more particularly the right to be heard. Now, the court said that no. The court responded to this and basically created another derogation, or we can say the context-specific reasoning, because it said, it really much stressed how all these measures came about, what was at stake, and so it stressed that there was an extraordinary context of extreme urgency, and so the effectiveness of restrictive measures that were put in place was at stake, and that these two factors in particular justify the limitation of these fundamental rights. It also stressed that this measure was part of this integral part of this strategy and package of sanctions that were adopted in a very short period of time to basically react to a grave breach of international law. It also stressed in this context too that what was at stake was also the preservation of the integrity of democratic debate in European society. The court basically recognized the position of the Council that the first days after the invasion of Ukraine were so important, and so it was crucial that the disinformation campaign that took place in that moment would not result in would not influence public in a way that would not be appropriate. So there was on the file there were evidence of very strong disinformation campaign that took place this moment, and the court recognized that and said that because of that, because these very important values were at stake, it was it was okay. It was not a violation of fundamental rights of defense. The fact that the person, Russia Today, in this case, was not pre-notified of the measures that were to be taken. Then there was another aspect related to the rights of defense, and basically that was the question of, as we call it in EU restrictive measures law, statement of reasons. So when you list people, you have to demonstrate that the reasoning complies with the criteria that were set for the listing. This is normally reflected in annexes, in the entries next to the persons on the list. Here, there was a different approach. This measure was part of the package of sectoral measures, where individual measures are very few. And so the approach that the Council took was that it basically explained in the recitals why Russia Today and similar companies had to be targeted in that context, and also and also explained that these measures could be maintained for what period of time. So that was also explained in the recital. And the court said, taking into account that we were talking about an entity that was fully owned by a Russian state, and giving also credit to the recitals that were provided in the legal act, and referring to the specific context and the fact that there was very serious and urgent conditions in which these acts were adopted, so said that basically these were circumstances certainly known to Russia Today. So Russia Today, its leadership should have known that this kind of acts could have been adopted in view of their role that they had in carrying out these disinformation campaigns. Now, the second very important part and key part, of course, of this judgment is the way it addressed the question of the interference with the freedom of expression and information. The court referred to the provisions that we have in the EU legal order, to Article 11 of the EU Charter, that basically has same content as Article 10 of the European Convention of Human Rights. It stressed the duties, increased duties and responsibilities as regards responsible journalism that applies to the audiovisual media, which are potentially more harmful than print media. And it then analyzed whether the conditions for limitations of such rights, which are listed in the third item there, are complied with. The court concluded they were complied with, especially, for example, I here would stress two elements: the respect for the essence of the freedom of expression. The court said that the freedom of expression, while limited, was not really undermined in its essence. Why? Because it was temporary in nature. Here I would just note that the court recognized the fact that these measures could be there in place for a very long time, because the criteria given in the recitals for keeping these measures in place were until Russia stops the war and until those athletes stop propaganda activities. So that was considered still of temporary nature. The court also recognized and said that only the broadcasting of specific content was prohibited, and said that those media outlets could still conduct research, interviews, and different activities, of course, even though those were pretty minor. And it also said that, of course, measures only applied within the EU, so they were free to broadcast their contents outside the EU. I see my time is running up, so I'll try to wrap up very quickly. So in the, when it basically assessed the proportionality of this measure, the court, what is interesting is that it looked really at the broad context. It refers to the United Nations General Assembly resolution, the order by International Court of Justice in the Ukraine v. Russia genocide case. It refers also to Article 20 of the Covenant on Civil and Political Rights, which basically prohibits war propaganda. And basically to the gravity of the violation at stake, and the fact that breaching obligation, erga omnes obligation, basically is something that is of fundamental interest to the international community as a whole. So all these elements convinced the court that in this particular case, the limitation of this right was proportionate. So finally, and with this I conclude, just to give you a little bit more of information of what kind of responses EU has so far adopted, and it keeps adopting. First, I mentioned just two cases of interest for people in this matter. We had in the past, basically, the EU has listed important people that were controlling media, and this is the case of Kiselev and Usmanov. Usmanov is a very recent case from February. Then I wanted to mention that this list, in view of the fact that the court basically upheld the Council's measures, the Council, this list is now growing. We've just added 14 additional entries in this relevant annex, and the latest editions, 6 editions we have just from now. It has also, just a few days ago, the first time the Council adopted asset freeze measures against 2 persons that were operating in Czechia and were basically owners of a media outlet which was basically spreading disinformation. I would mention also the European Media Freedom Act, which is the first European regulation of pluralism. and independence of media that contains an important article that allows adoption of certain measures even outside the context of the common foreign security policy, so in the very area of internal market legislation, if you want. So this is Article 17. And finally, European Union has also adopted the Digital Service Act with the Code of Practice on Disinformation that provides further elements through which the EU is trying to counter the disinformation campaign and manipulation of information. I will stop here now, and of course happy to respond to any questions you may have. Thank you.
Thank you so much, Petra. Are there any questions from the audience? Yes, Nick, do we have a microphone? Here is the first one.
Hello. Yeah, I had a question that is initially and predominantly for Ms. Grote, but Colonel Roberts in her talk also, I think I mentioned the same type of thing, so maybe you can expand on the answer. So in the presentation, or for the purpose of presentation, it seems that you was chosen to use effective control as a tool or a constitutive element for a likely data protection situation during armed conflicts. But when you take the whole joint area of operations, or even the whole of belligerent territories, I would think that, except from effective control situation, there is also probably the front line where fighting is hardest, and areas around the front line where fighting is likely or very likely. And then on the other side of the spectrum, you probably have areas that are approaching the status quo of pre-conflict. So in normal terms, like the edges of the conflict. In my country, the Netherlands, probably you won't have too much of those areas, but in a country like Ukraine or even bigger countries, it's likely that, you know, at the border of Poland, not too much happens, but data protection would be a thing everywhere. So my question is, do you think that different standards can also apply to different parts of the territories between the belligerents? I know it's a very broad question, but any thoughts you have, I'll take it, and any extra thoughts by Colonel Roberts.
So ladies who would like to go and answer?
If you don't mind, I'll have a go at it.
Go for it.
I think it's a wonderful question, actually, and it's a very valid question. Maybe just to reiterate, while I was focusing on kind of the core areas of effective control, belligerent occupation, I was focusing on that because I think that is where we see like the most systematic collection of data, because obviously, you know, if you want to control a civilian population, you kind of need to know who everyone is. In a situation where you use data for targeting, and I'm not of military practice, so maybe you'll tell me differently when we have a chat about this later, but I would think that there probably, you first don't have access to the entire population very often, and second, maybe you have a more of an like idea which people you exactly want to know more about, so it might be a little bit more discriminate. And the reason why I think it's valuable to focus on occupation is because there we have really this kind of like, I would say, somewhat indiscriminate maybe large-scale data collection. But you're very right, data is being used also in so many other situations. I think, now the first question is probably, so with regards to the applicability of the law of occupation, I think there we're getting into a very interesting general question with the law of occupation, and that is, how does the law of occupation relate to, for instance, the rules on the conduct of hostilities? Because in occupied areas, and this is not a new problem, sometimes you will actually have insurgent activities, and there will be, for instance, fighting. And yeah, so I think that question kind of also spills over into the data protection world, if you want, so of armed conflict, where you kind of have to think about, well, okay, so which areas are so effectively controlled that there's, for instance, a predominance maybe of the law of occupation and potentially even human rights law, and where do we really have to apply different rules? And I cannot give you a complete answer. There's a wonderful document by the ICRC where they have a whole chapter, and I think they had a whole day of experts debating precisely this question. mostly with a view to the right to, or kind of this idea of conduct of hostilities versus law enforcement operations. But you have that with data too, because when, for instance, would a operation be considered a cyber operation under the conduct of hostilities, and when would it be, for instance, I don't know, some law enforcement maintenance of public order related operation that just affects data. So again, I think I would not feel comfortable to kind of like speculate about this on this stage, but I think it's a very relevant question, and we'll probably have to go back to these debates kind of and figure that out. But I agree that data as it spans the whole spectrum. I think those are the kinds of questions we're increasingly dealing with. How do we even conceptualize this? Is this a thing of kind of targeting hostilities? Is it a thing of peacetime sometimes, or is it a thing of, exercising control?
Thank you, Tatjana. Anastasia, do you want to comment anything?
So I think you're going to have a very high level of control in the conduct of hostilities phase to think about applying the full range of data protection rights. But I would say at the same time, let's not think that states just go into armed conflict and suddenly they're cowboys. They don't care about the provisions they apply in peacetime, because that isn't the case. Certainly for the UK, even though I can't speak officially for the UK anymore. But certainly in terms of post-occupation, coming back, I know that data, when it comes back from theatre, is heavily safeguarded. And even though GDPR in its full sense may not apply because of the defence exemption, there is still an equivalent process. So I suppose what I'm trying to say is that in the conduct of hostilities, I think it's naive and unrealistic to think we can apply the full range of data protection, personal access to information that's held about you, etc. But by the same time, I think we should take some degree of comfort in knowing that certainly the NATO states, and NATO itself, of course, has a data protection policy that applies in operational context. There is still thought and consideration about these issues, but strictly, no, I don't think it would apply.
Thank you, Anastasia. Thank you, Nick, for the question. Are there any more questions in the audience? So you have a wonderful opportunity to think about the questions while I'm asking mine. Anastasia, do you think states will accept the broader interpretation of IHL, what you're suggesting in your presentation today?
So I think the fact that certainly NATO states already place policy limitations on themselves in relation to PSYOPs. So NATO PSYOPs policy is very clear that any PSYOPs must be attributable, they must be truthful, and they must be authorised. That is over and above what the law demands. So again, states actually do care about these things. As I said, you don't just move into armed conflict and it's a free-for-all. Nobody cares about personal data anymore. So actually, I do think that states will be amenable to a broader interpretation. But I think that's what actually we've been doing. As I've said, when I was on operations, I applied all of these provisions. It's not new. I think what is new is the fact that we're not used anymore to full war fighting in international armed conflict. We have become too accustomed to NIAC and situations below the threshold of armed conflict. So I think it's about relearning and retraining ourselves. But yes, based on the NATO policy, I would be very confident that states are happy to take a broader look at these issues.
Thank you, Anastasia. Any questions from the audience? There is one. Thank you.
So I'm Hele Maglar, Estonian MOD. The question about the IHL applying to autonomous weapons. Probably you are aware of the ICRC I'm not a lawyer. Let's start with this. ICRC has issued a call for United Nations Secretary General to think about a new legal peace treaty, whatever, on autonomous weapons, because in their opinion, autonomous weapons are not properly covered by the IHL. And probably as lawyers, you are very much aware why and how. But what's your opinion on this, and what's your expert advice for people in the governments? Thank you.
Thank you for your excellent question. Anastasia, would you like to answer that question as you've written paper on that one?
Well, I like the question. I'm not sure it's entirely within the scope of this panel, and I'm not sure, I'm certainly not qualified to give any state position on this. But personally, I think the use of autonomous weapon systems is utterly dependent on an Article 36 weapons review and whether those weapons can adhere to the law of armed conflict. And it's as easy as that for me. If somebody brings something to me and we can see that it does, without any difficulty, apply the LOAC principles and safeguard civilians and all of those other provisions, then I would not be averse to the use of lethal autonomous weapons. But it's all about the Article 36 review, and I think we're some way off really having such weapons that are capable of recognising hostile intent, hostile act, for example. So I'm not averse to it. If somebody comes to me, if I was still a military lawyer, as long as it had gone through the full Article 36 weapons review, then I would have no difficulty. But that's precisely what the Article 36 weapons review is for, to ensure compliance with LOAC. But again, that's just my opinion. My opinion is not reflective of any state opinion or of NATO.
If I may add to this, it's actually very interesting that you asked this question. I'm also by no means an expert on artificial intelligence or autonomous weapon systems. But what I will say is, if we look at how artificial intelligence works, and maybe the technology people in the room will know more about this, most likely, you need a lot of data. If you want a reliable system, if you want a system that works well, you need really vast training data sets to get to an algorithm that is actually useful and that would also be able to comply with all the obligations under IHL, basically. And I think this is where your question actually does kind of make sense in light of this panel, because I think that is a connection that might also be slightly underexplored. Where is that data coming from, And I think this is also where this topic really kind of could work very well together with all these questions related to the safety of such systems, because from what I understand about artificial intelligence, it is actually a lot about the data that you use to train it. So I wouldn't say right now, I'm not sure to what extent, for instance, you would be obliged to also consider the data when doing a weapons review.
You'd have to consider the training data, because of course that can produce bias in itself. So
I think these topics are very intimately connected, actually. And again, I cannot say anything about the general autonomous weapon systems debate, but that specific aspect, I think I personally find very, very interesting and very relevant to look at more.
Thank you for the question. I have one question also to Petra before we wrap up the panel. I would like to know, how does this case inform our understanding of the principle of non-discrimination on grounds of nationality in the context of common foreign and security policy? Would you like to comment on that one?
Yeah, thanks. That was one of the pleas raised also in this case, and it's a very common plea raised by persons of Russian origins, basically stating these are measures that discriminate us against on the basis of nationality. Now, in this particular case, the court was quite clear. The court said, well, this principle is also laid down for the purposes of application of EU law, is laid down in the provision of the treaty, so Article 18, that refers to the citizenship of the EU, and basically it regulates situations of discrimination on the basis of nationality within the EU. So you cannot discriminate between French and Germans and so on. So it will be very, very concrete. And so simply they said that their situation simply does not apply. This principle, as defined in the EU law, does not apply to them because they are foreigners. No, they are not a part of the EU. But the court also stated that basically this was not just discrimination on the basis of nationality, because the shareholder was Russian, but also that they were listed on the basis of the role, so the conduct they did of the role they carried out in the disinformation campaigns that was assessed to the great level of detail by the court, no? Because there was a lot of, I didn't speak about that, but there was a lot of evidence of what happened in these first 2 days after the invasion, and a lot of material showing basically that this was not respective journalism. So responsible journalism, and that basically what they were doing were trying to justify the invasion and so on. So in that particular case, it did not apply, no? And that I think it's correct. These were also arguments raised in other contexts that I know, and I think there is in the Universal Declaration also nothing prevents treating foreigners differently from. So this is not it's discrimination. Nationality is not one of the grounds on which you cannot discriminate against. No, if I refer to the more global framework, related to human rights. Yeah.
Thank you, Petra. With that, I see we are out of time. Thank you, everyone, for listening, and I wrap up the panel. Thank you.